Good morning.
Good morning, Judge Mincy. How are you today?
I'm good. How about you?
Good, thanks.
Miss Grace?
Yes, ma'am. How are you?
I'm good. How about you?
Okay.
All right. Who do we have first? In courtroom 2?
Come on. So 54, 55, Mr. Wells. Mhm.
I mean, there's no real trick here. You're the you're obviously going to take the offer give you, which is impossible to do. That's last time we asked because that's what to get up there. That you regardless of yeah, so you want to be prepared that you'll be free.
Good morning, Your Honor.
Good morning. It's going to be a plea.
That's correct, Your Honor.
What was the position again?
54.
55. Well,
Yes, man. How are you doing?
Yeah, well, okay.
all right. This is 26 CR 0022380 and 26 CR 003867E. Each has a count of criminal trespass.
No, it's not up to them yet.
Date?
Excuse me. Yes, good morning, Your Honor.
Morning.
On the case in 2238E, state recommends 12 months probation, 30 days to serve, stay away from all Georgia State properties, buildings, premises, campus, etc., and a social worker visit. On case ending 3867E, state recommends 12 months probation, 30 days to serve, and to stay away from Highland Bakery at 25 Park Place. We do ask that defense stipulate to ID, venue, and factual basis for purposes of the plea.
We do
Alright.
stipulate for the purpose of the plea, Your Honor, and that is the agreement as we understand it. Mr. Wells has been in for 15 days as of today.
All right, Mr. Wells, I understand that you wish to plead guilty. Is that correct?
Yes, ma'am.
All right, I'm going to ask you a series of questions to make sure you understand your plea and that it is free and voluntarily. Okay.
Yes, ma'am.
First question. Oh, raise your right hand for me. Let me swear you in first. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder your understanding today?
No, ma'am.
Okay. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you are prepared and agree to waive these rights today, correct?
Yes.
All right. And has anyone told you that you'll receive a lesser sentence for pleading guilty?
Yes.
They haven't told you that you would receive a lesser sentence just for pleading guilty, have they?
Yes, ma'am.
Um,
Your Honor, I believe he's referring to the offer from the state.
Other than the state's offer, have they promised you anything to get you to plead guilty?
No, ma'am.
All right, and and they haven't told you that you will receive a lesser sentence for pleading guilty, have they?
I'm not sure.
So other than what the state has said that they're offering, has anyone promised that you're gonna get a better deal just because of pleading guilty?
No, ma'am.
Okay, thank you. And do
You're
you
welcome.
understand that if you're currently on probation, that probation could be affected by your guilty plea today?
Oh, yes, ma'am. Yes.
All right, and do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
And as to the charge of criminal trespass in both of the cases, how do you plead?
Yes, ma'am.
How do
How do you plead?
either guilty or not guilty?
I'm guilty, ma'am.
Okay, guilty. All right, thank you.
You're welcome.
Just to confirm, these are balance suspended.
I'm so sorry, Ms. Strong. Yes, they are.
All right, thank you.
Thank you, Your Honor.
All right.
All right, we go to add-on number 4, Mr. Frank.
Hey, Frank, or you need a minute? He's the add-ons.
I thought it was-
No, he's not mine.
hold on, Mr. Frank. No, you good, go ahead. We go to 44, 45, Mr. No, I'm sorry, go to number 46, Mr. Smith.
All right. There's 46, Mr. Smith.
So it does look like it's going here.
And just for clarity, since there are two Mr. Smiths, this is Zachary Smith.
Okay, thank you. This is 26 CR 003896J. Zachary Bernard Smith, 1 count of theft by taking. State.
State recommends 12 months probation, credit for time served, an anti-theft course, excuse me. Stay away from 2430 McAlpine Terrace, restitution in the amount of $70. We do ask that defense stipulate to ID venue and factual basis for purposes of the plea.
Your Honor, we do stipulate for the purposes of the plea. Our understanding was that restitution was $40.
What did I say?
70.
Oh my gosh, I'm sorry. It is 40. I don't know why my mouth said that.
All right. And Mr. Smith, I understand that you wish to take a plea today. Is that correct?
Yes, ma'am.
Let me swear you in first. Raise your right hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. I'm going to ask you a series of questions in order to take your plea today, all right? Then make sure that you understand what you're doing. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder your understanding today?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And you do understand that if you're currently on probation, it could be affected by your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
So as to the charge of theft by taking, how do you plead?
Guilty, ma'am. Let me try it.
Guilty. All right. I'll accept your guilty plea. And I think that's it. Anything, Ms. Strong?
Who is the restitution being paid to?
State?
One moment. I know it's a fast food restaurant. I just don't know which one yet.
Okay, when we get these recommendations, can y'all please include all this information in here? Because this is information that we have to write on the send sheet to send over to probation when they get this information, not just the amount. We need to know who is being paid to, whether it's a company, a person, all this information we need. So you could put it in the chat so we can go on to the next person, but I need it put on the send sheet.
Okay.
All right.
Waiting for the judge.
Who do we have next?
Position 5 and 6, Ms. Hunt.
That's ridiculous.
Your Honor, that's gonna be a waiver, a not guilty plea at this point.
All right.
And we've waived formal reading, Judge.
All right. Thank you. And you said, oh, this is add-on 5 and 6?
Yes, Judge.
I was looking at the regular calendar. Sorry about that. All right, 5 and 6, Ms. Betty Jo Hunter waivers. They will be further noticed.
Thank you, Judge.
Thank you.
Next, we have position 39, Ms. Parker.
Your Honor, that will be a plea, Judge. Ms. Spear, well, Judge, I would ask the court to consider suspending the $300 fine, Judge. But other than that, it's a negotiated plea, Judge.
Right, let's see what we have. All right, this is 26 CR 003865H. Jordan Parker, charged with pedestrian in the roadway, pedestrian soliciting rides or business, and willful obstruction. Excuse me. And these are time served, please state.
Yes, with the exception of count 3, the statutory requirement for the $300 fine, which Mr. Haddad has asked to have waived, I believe is what he said.
It's a statutory fine, Mr. Haddad.
It is, Judge, but I believe the court has discretion to suspend. And the reason I'm asking for suspending is it's a time served sentence. If there's no fine, then she will not have to report to probation. She's of limited means, Judge. I mean, that's what it boils down to, Judge.
All right, I will suspend the fine.
Thank you, Judge.
All right. And Ms. Parker,
Thank you.
you're welcome. I understand that you wish to plead guilty today. Is that correct?
That's fine, yes.
All right, I need to hear you a little bit so the court reporter can hear your responses. Okay. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Speak loud, speak clearly. Yes.
Okay, put your hand down for me. And I'm going to ask you a series of questions to make sure you understand your plea, okay?
Speak loud.
Okay. All right. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that will hinder your understanding at this time?
No.
And are you satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence? I'm sorry?
Yes.
Okay. And do you understand that by pleading guilty, you're giving up and waiving the right to remain silent and not testify against yourself?
Yeah.
And do you understand that you're giving up and waiving the right to trial by judge or jury, whichever ever you prefer?
Yeah.
Yes. And are you prepared and agree to waive these rights today?
Yeah.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And you understand that if you're currently on probation, that probation could be affected by a guilty plea today.
I'm not currently on probation.
Okay. And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
Charges. So as to the charge of pedestrian in the roadway and pedestrian soliciting rides, how do you plead?
Guilty.
And as to the charge of willful obstruction of a law enforcement officer, how do you plead?
Guilty.
Guilty. All right. I will accept your guilty plea. And this is a time served plea. All right.
Thank you.
All right. You're welcome.
All right, next we got position number. Number 40, Mr. Perry. Next, yeah. Yeah, number 40, Mr. Perry.
All right. This is 40. Mr. Perry.
I just got an email from Mr. Judd on this, but I haven't had time to look into it. Do we want to do this?
We may need just a minute. I think it's a simple issue, but yeah, we may want just a minute for you to take a look at that. It looks like he was
Okay.
charged with 2 times for the same exact thing.
All right. Well, hold on him. Go to someone else.
Position 9, Miss Massey.
Okay.
We're gonna come back to you.
Your Honor, we're ready for a plea, but Ms. Spear may not. There might be some victim issues. We can do a bond hearing if there's not going to be an offer from the state ultimately. I mean, the offer's time served was last week, but I'll let Ms. Spear, I don't want to speak on her behalf, Judge.
All right, Ms. Spear.
We have not had victim contact, and we don't want to violate Marcy's Law or the Crime Victim Bill of Rights. So if we want to do a blind plea, we can. I have a note that our victim requires an interpreter, but that's the only contact that I know that we have had.
And Your Honor, the issue that's on behalf of Ms. Massey, Judge, is that this case actually started out as a felony before it got transferred to misdemeanor. She has still no bond on the charge, and she's been in custody since May 23rd of 2026. I mean, the recommendation initially was time served. I understand the state has not reached out to, or I shouldn't say reached out, have not been able to communicate or make contact with the alleged victim, but from their own valuation, that they believe that this is a time served sentence. I mean, the recommendation is 60 days, but she's been more than 30. And we're in a situation that Ms. Massey is trying to get out. Would like to resolve the. I mean, bottom line is she wants to get out, Judge. And I'd hate to have to reset it. Which is why I'm kind of asking for a signature bond if at all possible. There's always a risk with a non-negotiated plea, as the court is aware. So that's where we're at.
And which number is Miss Massey? I just don't see a Massey on my list.
It's an add-on position number
9.
9.
Oh, it's on the back. Okay. Sorry about that. This is a simple battery charge, 26 CR 003578Y. And she doesn't have a bond. She's been on the calendar before too, or no?
She has, Judge. She was on the calendar, I know, last week, but they erroneously took her downtown, so she was never able to uh address this matter. Uh, that's as far as, last week. She may have been on the calendar the week before. I don't know. I have to look it up, but I know last week. So when it got transferred from felony to misdemeanor, at the time, felony did not have a bond for her. It was accused, as the court is aware, and it was accused as a battery. But the booking screen, she still has no bond, and she's of course entitled to a bond on that case.
In state, I would be inclined to have a bond hearing today at the very least.
That's acceptable.
Is pretrial here for the history?
Good morning, Your Honor. I am.
Good morning.
Is this Kirsty Massey? Because I don't know if I have the add-on.
Yes,
But I was
It is.
Kirsty,
Kirsty
okay.
Michelle Massey.
Okay, one moment. Hold on.
Okay.
Okay, so there are 5 cycles total. There is an first offender in 05 out of Cobb County for manufacture, sell, dispense, or distribute reckless conduct and purchase, possess, or control drugs. And then there's an 02 conviction out of Cobb County for harassing phone calls. In one moment. Nothing further to report.
All right. State.
Yes, Your Honor. Just checking I wasn't muted.
Oh,
Um,
okay.
The state's biggest concern is that this was a felony, and so we would ask that a reasonable bond apply. Normally for batteries, we do 2,000 unless there's a reason to go higher. Simple battery, I would probably ask another 2,000. I'm just pulling up to make sure, since this was originally a battery, what the injuries are looking for. Let's see. Miss Massey hit the victim in the face with a black umbrella, continued to hit her with her fist, and then hit her with a wooden hanger. There is video of this altercation. So I would think that a total of $4,000 surety is more than generous in light of the fact that it was supposed to be a felony in the beginning, with no further contact with the victim, whose name I'm going to try to pronounce, Stephanie Gintoli, Gintoli, and to stay away from the incident location, that is the hotel where it happened. Let's see, 5455 Windward Parkway, Comfort Suites. No drugs, alcohol, or weapons while on bond.
All right. And Mr. Haddad?
Judge, on behalf of Ms. Massey, she's 55 years of age, Judge. The stay away is not an issue. She's worked off and on. I'm not sure right now. I mean, she's been in custody since May 24th. The DA's office did not deem it to be a felony. I would ask the court to consider releasing her on signature bond. She has pretty limited criminal history, Judge, but through pretrial services, whether it's level 1, level 2, or level 3, I'll leave it up to the court. But I think, under the circumstances and the lack of history, I think, being monitored through pretrial services would be a good way to make sure that she reports back to court, which is the first priority. She doesn't have a history of FTAs that I'm aware of. And I think she is eligible for pretrial services.
All right.
May, she was recommended for level 1.
Thank you. All right, I will grant her a $4,000 signature bond through pretrial. And with that bond, she will be at a level 1. I'm going to order that she have no drugs, alcohol, weapons, or guns while on bond. That she stay away from the incident location, I think it was Comfort Inn on Windward Parkway, that she had no further contact with the victim. And I believe that's it.
Judge, is this
Anything
two
else,
on-
counsel?
Is this two on each?
I only have one charge. Are there two?
Battery and simple battery is what I have.
Oh, there's two. I'm sorry, it's at the bottom. I didn't see it. Yes, 2,000 on each. I'm sorry.
Thank you, Judge, and I'll prepare the order and submit to Ms. Strong for the court's review, and I'll CC Ms. Spear.
All right, correct. Thank you.
Thank you.
All right.
All right, next we got position number 27 and 28, Ms. Goldberg.
All right.
And good morning, Judge Mancy. This is Public Defender Alex McKay here from Ms. Goodrum.
Yes, good morning.
Hey, Alex.
Hey, Jennifer.
All right, 27 and 28, Goodrum. And this is going to be a plea.
Yes, Judge.
Okay. This is 24 CR 001307D, and then the 26 FTA ending in 1116. State?
Yes, Your Honor. In exchange for the plea to the case ending in 1307D, we are going to null pros the FTA ending in 1116. In position 27, we are asking for 12 months probation, no further contact with the victims, Ron Kirkpatrick and Claire Dent. Stay away from 364 Auburn Avenue and a social worker visit. We ask that defense stipulate to ID venue and factual basis for purposes of the plea.
Defense stipulates, Your Honor. We also request a waiver of the first month of probation fees, and if possible, to have her go non-reporting.
State, any objection to the non-reporting?
No.
Okay.
I'm sorry, Judge, before you continue, what is she on probation for? I can't hear you, Ms. Spear.
I was yelling at my kid.
Oh, I'm sorry. What is she on probation for before we continue?
This would be a balance suspended, it looks like. So she would, so she would be on probation theoretically for the criminal trespass in this.
I'm sorry, say it again. So it's the 12 months probation, but she's not on probation. This is a balance suspended, is what you're saying, correct?
Yes.
My apologies, Judge. I'm ready now.
Okay. So then it would be balance suspended. Okay.
Yeah, that's on me. I keep forgetting to say that, and I'm annoying Ms. Strong by doing that. I apologize.
Okay, no worries. All right, Miss, now that we're clear on that, and I'm waiving 1 month, the probation. Well, she won't have it, sorry. And Miss Goodrum, are you ready to take your plea? Hello?
Yes,
Can you hear me?
yes, ma'am.
Okay, raise your right hand for me so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. I'm going to ask you a series of questions to make sure that you understand this plea, okay? All right, you can put your hand down for me. All right, first question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder you from understanding today?
Yes,
I'm sorry?
yes, ma'am.
You're not under the influence of any unprescribed medication, are you?
No,
All right. And are you satisfied with the services and representation of your attorney?
yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes,
That you're giving up and waiving the right to remain silent and not testify against yourself?
yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you would prefer?
Yes,
And you are prepared and agree to waive these rights today, correct?
yes,
And that, has anyone told you that you'll receive a lesser sentence for pleading guilty?
no,
Has anyone promised you anything to plead guilty?
no,
And do you understand that if you're currently on probation, your probation could be affected by a guilty plea today?
yes,
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
yes,
And so as to the charge of criminal trespass, how do you plead?
guilty,
Okay, I will accept your guilty plea, all right?
yes.
All right, good luck to you.
Next, Your Honor, is position 13 and 14, Ms. Boyd.
Okay,
13
Honor,
and
that-
14.
Judge, that's gonna be a negotiated plea.
all right. This is 24 CR 004317E, and then the FTA, 26 FTA ending in 1060. And the charge is battery family violence. State?
Yes, Your Honor. In exchange for the plea to case 4317E, we are willing to null pros the FTA ending in 1060. In the case ending 4317E, state is requesting 12 months probation, balance suspended. I remembered, Ms. Strong. Credit for time served, FVIP $400 or 40 hours of community service. No further contact with the victim. I believe it's pronounced Dante Wyke or Weich. Stay away from the extended stay at 1950 Rock Mill Road. We do ask that defense stipulate for purposes of the plea.
And Your Honor, we stipulate for purpose of the plea, we are requesting 40 hours community service in lieu of the fine. I did want to point out to the court that Ms. Boyd, when she was first arrested back July 1st of 2024, she spent 44 days before she went straight to the Department of Corrections. Her parole was violated. She has been in continuous custody since July 1st, Judge, of 2024. And she was brought from the prison to deal with this case. So technically, really shouldn't have been a failure to appear, but nonetheless, she wishes to resolve the case, Judge. I would ask the court to consider, under the circumstances, to waive her first 2 months of probation fees. She does reside in Troup County, so I'm going to ask the court to allow her to report by phone. But other than that, Judge, she wants to resolve the case and she'll abide by all the conditions imposed by the court.
And there are
All right.
conditions, so it would be balanced, probated, not suspended. I was so excited to make Ms. Strong happy. I said the wrong thing.
Okay. I'm going to obviously allow her to report by phone since she will be in Troup County. And I will waive 2 months of the probation fees. And then I had the 40 hours community service already in lieu of the fine.
Thank you, Judge.
All right. Ms. Boyd, I understand that you wish to plead guilty. Is that correct?
Yes, ma'am.
All right. Raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Put your hand down for me. I'm going to ask you a series of questions to make sure you understand your plea, okay?
Yes, ma'am.
Are you under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding today?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
and that you're giving up and waiving the right to trial by judge or jury, whichever you prefer.
Yes, ma'am.
And you are prepared and agree to waive these rights today, correct?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, it could be affected by your guilty plea today?
So can I ask a question?
Okay, what are you gonna ask me?
I'm still on parole, so is that gonna affect that too?
Should have had that conversation with your attorney.
It would not because your parole was already revoked.
Okay.
All right. And so do you offer this guilty plea freely and voluntarily with your full understanding of the charge against you?
Yes, ma'am.
So as to the charge of battery family violence, how do you plead?
Guilty.
All right, I will accept your guilty plea today and good luck to you.
Yes, ma'am. Thank you.
All right, you're welcome.
I'm sorry, just to confirm, this was just the telephone recording and waiving 2 months of probation, and that's it, correct?
Correct.
Okay, thank you.
All right, next we got 41, Mr. Ponder.
Usually pleading. Oh my God, oh my Lord. Oh.
I have that as Ms. McLeod's case. Is she here?
Oh,
don't
this
see
is
her.
Ms. McLeod. Is she here or the Murphy you filling in? Don't want to put you on the spot.
Judge, I'm here on 21 and 22 Downing,
Oh, okay.
and I'm not
Oh,
down back in town, so to speak.
yeah, he's gonna be a medical reset.
Okay,
Medical reset. Okay.
okay. Will that be next Thursday, Judge?
It should be.
Okay, duly noted, Judge, and I'll try to raise Miss McLeod and tell her that she's expecting her appearance.
Okay, thank you.
I apologize. Which one was the medical reset?
20.
Mr. Murphy's 21 and 22.
Okay,
Is
thank
it Jamilith Downing? Then Miss McLeod is on 41, Otis Ponder, but we'll hold for her. We'll have to take someone else.
Position 51 and 52, Ms. Venable.
Okay.
Your Honor, we may have to revisit her unless Ms. Spear has a recommendation. Oh, here we go. All right, Judge, if we may have to have a bond hearing on this matter, Judge.
Uh-huh.
So we're ready to proceed, Judge. I think similar situation as before, the state does not have a recommendation for inability to make contact with the alleged victim, Judge.
My apologies. What position is this?
51 and 52.
Okay, thank you.
And that's correct, Your Honor. We haven't been able to reach the victim, and this is a battery with substantial physical harm, so we definitely don't want to violate Marcy's Law or the Crime Victim Bill of Rights on this. We can have a bond hearing if Mr. Haddad would, that's fine with the state.
All right, 22 CR 003233E, Diana Venable. And then, of course, the FTA is 26 FTA ending in 1074, battery, substantial physical harm, pretrial.
Yes, Your Honor. Am I muted? There are 11 cycles total. There's a
I'm sorry, say that again.
11 cycles total. There's an FTA in 2026 out of Folsom. That's probably the one that's on the calendar. And then there's another FTA in 2023 from DeKalb County. There's a 2023 criminal trespass out of DeKalb County conviction. One moment. There's a 2018 disorderly conduct from Fulton County. Another FTA in 2013 out of Fulton. There's a 2010 conviction out of Muskogee County for possession of marijuana less than an ounce and prostitution. Let's see, nothing further.
All right.
And Your Honor, I don't know if the court wanted to hear from me or the state first.
State.
Yes, Your Honor. This was part of a jumping, if you will. The victim says she was jumped by two women. One of them was the defendant. She was pushed to the ground and actively punched and kicked while she was on the ground by a total, it looks like, of 3 people. Based on the number of FTAs, state would definitely need a surety on this matter. State's going to ask a $7,500 surety, no further contact with the co-defendants or the victim, and to stay away from 198 Peachtree Street, which is the incident location. No drugs, alcohol, or weapons while on bond.
All right.
And Your Honor, I'm simply requesting the bond to be changed from $3,000 cash only to a $3,000 surety bond. I was not requesting under the circumstances a pretrial due to the failure to appear. But I mean, at this point, she's clearly unable to make a cash bond, and I'm asking to change it to a surety bond of 3,000, and we're gonna waive and enter plea of not guilty on her behalf, Judge.
All right. And she's been in custody how long?
Your Honor, she has been in custody this time since June the 10th, so 15 days. And initially when she was first arrested, the day, so 16 total days, Judge.
All right. And what about her contacts or things with Georgia?
Your Honor, I mean, she is from Georgia. I think I can provide an address to confirm, but she's local. And you know, her family is here. I don't believe she was employed just before she got arrested on the failure to appear, but she can confirm, Ms. Venable can confirm. I did not neglected to ask her that specific question, Judge.
Okay. Just making sure. So the existing bond is a 3,000 cash. I will amend that to a $5,500 surety bond. With that surety bond, no further contact with the co-defendants or the victim in this case. Stay away from the incident location, which is 191 Peachtree Street. I think I heard. No drugs, alcohol, weapons, or guns while on bond. And that should do it.
And if I can ask Ms. Spear, since I don't have discovery, if you can just email me the names of the co-defendants so I can put it in the order.
Absolutely.
Thank you, Ms. Spear.
Absolutely.
Thank you, Judge.
All right, thank you.
What position was this that we just did?
51.
Thank
All right, let's have 36, Mr. McCray.
Okay.
This is gonna be a plea, Your Honor.
I'm sorry, I
Okay.
missed that. I was getting ready to do my email for Mr. Haddad. What number are we on?
36.
Thank you.
Mr. Qantas Copeland,
McRae. All right, this is position 36, 26 CR 003456J. Travell McRae. State.
Yes, Your Honor. The state recommends in this matter on count 1, 12 months probation, credit for time served. Count 2, 12 months probation, credit for time served. Count 3 is the statutory $300 fine. Balance suspended or probated, I guess, will depend on whether Your Honor wishes to convert the fine into community service hours or suspend the fine entirely. State asks defense stipulate to ID venue and factual basis for purposes of the plea.
Your Honor, we do so stipulate for the purposes of the plea. We are asking that the fine be suspended and that be allowed to go probation suspended. Mr. McCray has been in jail for a while now, and he does have other cases that he has to handle. We're not sure when he's going to be able to be financially solvent enough to make these payments.
On that statutory fine, he will be getting out, I'm assuming. So could he do community service or not?
Your Honor, if Your Honor is unwilling to suspend the fine, he would prefer to have community service instead of a fine.
I don't know what his history is, but I will convert it to community service, 30 hours of community service.
And Your Honor, may his probation be terminated upon completion of community service.
Any objections from the state to terminate?
If I recall, he has a kind of lengthy history, so the state is reluctant to consent at this point. If I recall correctly, the officers had recognized him from previous interactions.
And the reason we ask, Your Honor, is he is already currently on some felony probation, so it's not as though he's going to go unsupervised. This would just add one more hurdle for him to try and keep track of everything.
Okay, if felony probation's keeping an eye on him, then no, we don't object.
Okay. All right, so we'll terminate on completion of the condition. And I think that's it. Mr. McRae, I understand that you wish to plead guilty. Is that correct?
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. Gonna ask you a series of questions to make sure you understand your plea, all right?
Yes, ma'am.
All right, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding today?
No, ma'am.
And are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, it could be affected by this guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
So as to the charge of alcohol sale near church, school, or building, how do you plead?
Yes.
To pedestrian darting out in traffic, how do you plead?
Yes.
And as to willful obstruction of a law enforcement officer, how do you plead?
Yes.
All right, I will accept your guilty plea.
Thank you, Your Honor.
All right, thank you.
Next is
Mr. Ar-
position. I'm
Go
sorry.
ahead.
Position 56, Ms. Williams.
All right, hold on 1 second.
Yes, Your Honor.
Okay. All right, thanks so much, everybody. I appreciate it. Yes. Okay, number 5 is Rocky Green. Green. Are you representing Mr. Arnold? Okay. Okay. I would say, are you, I said, Mr. Arnold, going to put down, you know, do we need to wait for the enforcement? We go right to enforcement. Okay, Ms. Fowler. This is the state of Georgia versus Robin Green. This is 23 SC 191. Mine is number 8. Today is June 25th, 2026. And the defendant in this case, Mr. Green, is in custody and he appears today via Zoom. His attorney from the public defender's office is Mr. Nathaniel Horsley. And answering the calendar today for Mr. Horsley is Mr. Charles Arnold. And the state of Georgia.
All right, this is position 56.
Yes, Your Honor.
Possible resolution, and that he is authorized.
And is this going to be a plea?
No, Judge, it's a bond hearing.
All right. This is 09 CR 34675, Alicia Williams.
Yes, Judge.
All right, pre-trial.
She has 18 cycles total, 1 from Pennsylvania, 11 from Nevada. There's a 2024 conviction for possession of drug and larceny, a 2022 conviction for trespassing, 2019 conviction for use, possession of drug paraphernalia, 2019 conviction for trespass, another 2019 for false statement to obstruct public officer, a 2018 conviction with the same charges, and then another 2018 for use, possession of drug paraphernalia. There's an open case out of Cobb County for possession of marijuana less than an ounce, and a 2011 conviction out of Sandy Springs for DUI. Nothing further.
All right. State.
Yes, Your Honor, being that this case is old, I'll concede that. However, most of her criminal history happened after this. And so the state, I believe it's $3,000 right now. The state feels that in light of the fact that she has another DUI, she has multiple open cases, and she's a multi-state offender, we feel that's more than generous at this time. And the bond should remain with no drugs, alcohol, or weapons while on bond.
So the present bond is a 3,000 surety.
That's what I show. Mr. Haddad, do you have something different?
It shows 1,300.
Oh,
1300 is at least the booking screen. That's what it shows.
okay. I will double check.
Let's see, make sure. And when you get to the booking screen, what date are we showing for the arrest?
Your Honor, for this arrest, it's June 12th, so she's been in custody 14 days.
All right, thank you.
Oh, he's right. I apologize. It is 1,300, not 3,000. And I do show the same booking information.
Okay. So what is the breakdown?
Your Honor, the booking string doesn't have a breakdown. It just has 1,300 on one of the DUIs. The other has a 0.
That's correct.
Which DUI? Let's say
The-
for
The first one, drugs and alcohol.
okay, 1,300 on the first one, and then the other two don't have a bond.
Correct. And it is a surety bond.
Okay. And what I'll do, we'll stay with the 1,300 on the DUI, drugs, and alcohol. Mr. Haddad, do you want to add anything?
Your Honor, I mean, my client relayed to me that she is able to bond out as is with the 1300, but she remained in custody for 14 days in the hopes that the state is going to dismiss. What I explained to her is even though it's an old case at this point, the state does not really have to, and they may be forced to when the case goes to trial. She lives in Las Vegas, Judge. She was here on for a funeral, and she was jaywalking. That's when this warrant popped up. I mean, she relates to me. She was unaware of this case. It's so old, from 2009. I don't really have any information as to what transpired as far as this particular case from 2009 until today. But I would just simply ask the court to, I mean, if the court is willing to reduce the bond, we'll take it, Judge. But she does have family. I've been in touch with them, and they're going to assist her with bonding out. And it's just essentially going to be a waiver at this point. I did explain to her that to fight these charges, she's going to have to come back to court whenever she gets court notice.
All right. I'll leave the 1,300 surety on the first one. On the following two close, 500 surety bond, and then the other DUI, let's say $1,000. So that'll be a total of 2,800. My math is correct.
My math is always incorrect, so I will take your word
That's
for it.
correct, Judge.
Right, 2,800 surety. She is to, as far as the conditions, she is to not drive unless she has the proper credentials. I almost want to tell her not to drive at all due to her history, and she's gotten the I think it was a 2011 DUI conviction out of Sandy Springs.
Your Honor, is the court's intent to increase Ms. Williams's bond? Because right now she has a $1,300 bond.
Yes, it is my intent to increase it because of her history and because she lives out of state. So we do want to make sure that she intends to come back. So it is my intent to increase it from 1,300 to 2,800.
All right, Judge, and I'll prepare the order.
No drugs, alcohol, weapons, or guns while on bond.
Thank you, Judge.
All right,
And
thank
we
you.
waive, Judge. Thank you.
Okay, thank you.
All right,
And I
if
see Ms. McLeod has gotten on. Good morning.
Good morning, Your Honor. I apologize for being late, but I had another calendar that I just got out of.
No worries, I understand.
Your Honor, I believe ACDC had a question.
Yes.
Oh, yes, I'm sorry.
So what is this?
It's the total bond is 2,800.
That's a signature bond?
No, it's just through a
Surety.
surety bond.
Okay.
Can you explain to him that I'm on disability and I don't?
And Your Honor, what I neglected to mention is the fact that my client used to work in logistics warehousing. She was injured on the job 2 years ago, and she's limited income she receives disability. However, my understanding is the family that's going to post the bond and not her.
Right. Yeah, I won't reduce it because of course the 1,300 was just on the one DUI, but she had the two other open charges, and her history with 18 cycles in three different states: Georgia, Pennsylvania, Nevada. Going back to Nevada is just too risky to not give her too risky to give her a signature bond, which I won't do. And then I needed to add bonds on the other two charges that had no bonds. So I think 2,800 is more than fair, given her history. All right.
Thank you, Judge. I think
Thank you.
if I'm communicating with the solicitor, judge, and other prosecutor, and we may be able to potentially have a resolution on this case, Judge, later
Okay.
on. But I don't want to keep anybody hold up on anybody else. So, thank you, Judge.
Okay. We can come back to it if we need to.
Thank you.
All right. Thank you.
That's about 44, 45, Mr. Smith.
Okay.
Right.
44 and 45. Is this going to be a plea?
It is, Your Honor.
This is Jaden Smith, 23 CR 0080488, battery, family violence, and then the FTA with that one, 26, ending in 1118. Okay.
Yes, Your Honor. In exchange for a plea to position 44, case ending 8048H, state is moving to null pros. The FTA in position 45 ending in 1118. For case ending in 8048H, state recommends 12 months probation, 90 days to serve, balance probated, 100 hours of community service. Although this is an FVIP case, we are recommending the 12 hours of anger management. MHET, per the victim, no further violent contact with Shannon. Oh, I'm going to say this wrong. Ajobo. I don't know how to say it. IJAOBO. My apologies. Stay away from the incident location at 6885 Peachtree, Dunwoody Road. We do ask defense stipulate for purposes of the plea.
Your Honor, we do so stipulate for the purposes of the plea. My math has that Mr. Smith has been in for 62.
Okay. All right. Mr. Smith, I understand that you wish to plead guilty. Is that correct?
Yes.
All right. Raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. Put your hand down for me. I'm going to ask you a series of questions to make sure you understand your plea. Are you presently under the influence of any unprescribed medication, drugs, or alcohol at this time that would hinder your understanding today?
No.
Are you presently satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yeah.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yeah.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer? Sorry?
Yes.
Okay. And you are prepared and agree to waive these rights today, is that correct?
Yes.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And you do understand that if you're on probation, it could be affected by a guilty plea today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
All right. So as to the charge of battery, family violence, how do you plead?
Guilty.
All right. I will accept your guilty plea and you understand you got some conditions here. Okay.
Thank you.
All right. Thank you.
We'll go to 47 to 50, Mr. Spear.
Okay.
No, that's why.
Spear.
I just show conflict. I don't have an attorney or announcement on this one.
Okay. Casey.
Last name Spear 47 through 50.
Your Honor, that was a request of a conflict that was recent. I think I sent the email 2-3 days ago. I don't believe anybody has been assigned, so either Ms. McLeod or Mr. Murphy can be appointed.
All right. Ms. McLeod still on, Ms. Strong? Or did she get?
Oh, yes, she is still on. Yes, ma'am.
Oh, okay.
Your Honor,
Position
I am
Ms.
here.
McLeod, DeMarcus Spear. Have they assigned that to you?
They have not, Your Honor.
Okay, we're either gonna have to reset him or,
Your Honor, Mr. Spear has other issues, legal issues, Judge, so a reset is not gonna affect it in the grand scheme of things, Judge.
all right, so we'll reset those to
Oh,
next
Your Honor,
Mm-hmm.
if the court is asking me to represent him, I can do so. But of course, I would need to file the appropriate pleadings into the case so I can get some discovery that I can properly speak to him about this case.
Right. Well, we'll reset it for next week if you want to do that.
I mean, he has multiple cases, but I think 2 are FTAs and one's been null prost and the other one's a standard shoplifting offer. I understand, Ms. McLeod, that you always go through all the appropriate motions, but just making everybody aware that although he has multiple cases, this is not what it appears to be on its face.
Right.
I understand. And since he has multiple cases, we don't have to rush. He can, it's not gonna harm him because I understand he would not be getting out of jail even if we address these cases today.
Correct. All right, we'll reset it for next week.
Yes, Your Honor.
What positions were these again?
47 through 50, Jamarcus Spear.
And do you mind if I ask a question about position? I'm sorry, before we go on to the next one.
Mm-hmm.
Sorry. Position number 33. I know Ms. Spears sent she sent a recommendation, but it was also marked for a waiver. Did you all want Mr. Judd? I just want to know because his mother is here and we need to know whether she should log on or not.
For 33?
Yes, ma'am.
I believe Mr. Haddad, and I could be wrong, said that they wanted to stand by that waiver, but
okay,
Right, that was a waiver.
Okay, I just wanted to confirm because Ms. Spears sent me an offer before we gave his mother any information about logging on.
We're standing by that waiver.
Okay, thank you.
Okay.
All right, let's have 41, Mr. Condon.
Okay.
I'm sorry. Before we proceed, Mr. Judd.
Yes.
Mr. Jordan asked, did you realize that he's in on no bond before we waive it? That charge has no bond on it?
Oh, I'm sorry.
I apologize, Judge Manson.
No, it's okay.
We're on Marquand.
Position number 33, the one I was asking you about.
Understood. Your Honor, I didn't speak to him about the Ayala factor, so we would like to have a bond set. I don't really have anything to argue in favor of a signature bond, so I would just go ahead and ask for one. But we do need a bond set on the charge.
Okay. And he is 33 and 34.
That's correct.
And need a bond on both cases. I'm guessing.
I believe he only doesn't have a bond on 2915E.
Oh, just on 33.
I believe so, Your Honor. I mean, please someone double check me, but I believe so.
All right, let's double check, make sure.
So position number 33 is the one that doesn't have a bond.
Okay, and 34 does. Okay. Is this Mr. I don't know how you pronounce the last name. Is it Jagney?
Mr. Yagney was not brought down, Your Honor.
Oh, he was not brought down.
No, I believe this is a conflict case sitting next to me.
Who's representing him? You are Mr. Judd?
No, Your Honor, this is a conflict case. I believe this is Ms. McLeod's.
Oh, Miss McLeod, I'm sorry. You're back.
Yeah, 41.
And Ms. McLeod, do you have 33? Mr. Marjan Jagny?
Judge, no, that says Mr. Judd on the announcements for
Yes,
33 and 34.
I had Mr. Marwan yet.
Right, I think Judge is asking about the one that we asked Ms. McLeod for. That's not this case right here for the defendant.
Which one is that? I'm sorry, Ms. Strong.
No, I was saying the defendant sitting beside Mr. Judd is the one for you. I'm assuming, correct, Mr. Judd?
Yes, the
Okay.
next
Yes.
to me, Otis Ponder, number 41.
Correct.
What is his
Oh.
name? I'm sorry, I do not have the calendar. I just sent
Otis
asking for it.
Ponder.
Mayor McLeod.
Oh,
Otis
yes,
Ponder.
Mr. Ponder is my client. Yes.
All right, let's do Mr. Ponder, who's in the chair real quick, and then we'll come back to the other one. All right, 26 CR 003849E, Otis Ponder. Charged with one count of simple battery against police officer or detention officer.
I threw shit all
Your Honor, there was no offer for Mr. Ponder. Also, he is being held on other charges.
There was an offer
I-
set, Ms. McLeod. You didn't get it?
There was an offer sent?
Yeah.
I did not. I had received a calendar from the litigation manager, and it had no offers on it.
No, ma'am, these offers were sent between early this morning, so that would not have been on the information that you received, Ms. McLeod.
Exactly. That's what I was saying. I have not received that. So something has been sent. I do not see.
It's 12 months probation,
I
30
see.
days
I-
to serve.
Hold on, Miss Spear, hold on. What were you saying? Our Miss McLeod is looking at her email, hold on. Either way, she's gonna have to
Yes.
talk to the client, correct?
Yes, Your Honor, I do have to talk to him. And there are some other things, I believe, holding him in jail. Is that correct, Ms. Spear? Because this was an incident that happened in the jail. That is my recollection from his first appearance.
That is
So
correct.
he
This
was-
happened in the jail.
Right, that's my understanding. So I do not believe any kind of resolution today is going to allow him to get out. And just based on my interactions with him, I think he may be a candidate for the 11 o'clock calendar.
Mm-hmm. Mm-hmm. All right, are we moving into 11 o'clock? Resetting. What are we gonna do?
Your Honor, I am going to file a motion for an evaluation.
Okay,
So would you like to do next Thursday or the 9th, Ms. McLeod?
I think the 9th is,
The 9th?
yes, because even when I file the motion, I think it takes about 30 days for the evaluation to even get done.
all right. So this case will be reset to July 9th. Anything else on Mr. Ponder? Nope.
No, Your Honor.
All right, thank you. And now we're going to which number?
You want to add
Your
on?
Honor, I have another client on the calendar.
Who is yours, Mr. Cloud?
He is I'm sorry, Your Honor. I'm going through my notes. I'm having a little bit of a
I have James
Mr.
Arnold as
Arnold.
yours.
Yes, Mr. Arnold. Yes.
Okay.
Days off. Oh, he's also gonna be also a medical reset.
All right.
Yes. And I also believe he should be on the 11 o'clock calendar.
Which
All right.
position is this?
Number
3 through
3.
8.
3 through 8.
38?
3 through 8. 3,
Oh, 3
4?
through 8.
Yes, he has several cases. They were pending before Judge Besson, Your Honor, but unfortunately, he did not. He missed court.
All right. So positions 3 through 8 for Mr. Arnold will be reset. Is that July? Is it 8th or 9th?
9th, I believe I heard said.
9. And this is
Okay.
for the 11 o'clock calendar as well?
Yes.
Okay.
Yes.
Yeah.
All right. Now who do we have?
Yeah, and on 4, Mr. Frank.
Add on 4. This is Akeem Frank, 26 CR 003344G. It's going to still be a plea.
Yes, Judge.
All right. State.
Yes, Your Honor. Count 1, theft by shoplifting. State recommends 12 months probation. Balance suspended or probated will depend on count 2. Credit for time served. Stay away from the Walmart at 6149 Old National Highway. Count 2 is the statutory $300 fine, which again will defer to Your Honor as to how you want to move forward. We do ask that defense stipulate for purposes of the plea.
Defense stipulates, Judge, we'd like it to be balanced and suspended. At least to have him go on reporting the T, pay you the fine.
I have no objection to non-reporting.
Okay. All right, Mr. Frank, I understand that you wish to plead guilty. Is that correct?
Yes, sir.
Raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, sir.
All right, put your hand down for me. I'm going to ask you a series of questions to make sure you understand your plea. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder your understanding at this time?
No, yeah.
All right, are you satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yeah.
You're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
And you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yeah.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
And has anyone told you that you receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And you do understand that if you're currently on probation, it could be affected by your guilty plea today?
I understand.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
All right, as to the charge of theft by shoplifting, how do you plead?
Yes.
And as to the charge of willful obstruction of a law enforcement officer, how do you plead?
Yes.
All right, and I would accept your guilty plea. I will enforce the statutory fine, and once he pays that, then he can go non-reporting, I believe. Is that correct?
No objection from the state.
Okay. All right. That should be it.
Yeah, I mean, my honest said for.
This got one. Arnold.
I think Miss McLeod forgot to mute.
Yeah, Miss McLeod. Oh, did she do it now?
I am here, Your Honor.
Oh, you weren't muted. We were hearing your conversation. Oh, there you go. Thank you. All right, who do we have next?
1 and 2, Mr. Arnold.
Okay,
That's a negotiated plea, Judge.
all right. This is 26 CR 001721B Cody Arnold, and then the FTA ending in 1059. State?
Yes, Your Honor. In exchange for the plea to the case ending 1721B, the state has agreed to null pros the FTA ending in 1059. For the case ending 1721B, state recommends 12 months probation, credit for time served. This will be balanced probated for an anti-theft course, a $500 fine, and to stay away from the Family Dollar at 1616 Virginia Avenue. We do ask that defense stipulate for purposes of the plea.
Defense stipulates, Your Honor. We also ask for a waiver of the first 3 months probation fees and for probation to go non-reporting once Mr. Arnold completes the requirement.
Based on the FTA, the state would object to non-reporting at this point.
I can only waive 1 month of probation fees here. And I think that's it. Ready to take your plea? All right, Mr. Arnold, do you still wish to plead guilty? Can't hear you.
Yes, ma'am.
Okay, raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Just a moment,
All
Your
right,
Honor.
do you need a second? Speak to your attorney?
He needs a moment.
Okay.
Your Honor, may I make an announcement?
Yes.
Yes, I believe I have addressed all my cases on the calendar, on this particular calendar, so may I be excused until the 11 o'clock calendar?
Yes, you may. Thank you.
Thank you, Your Honor.
All right.
We'll continue with the plea colloquy, Judge.
All right. And so now that you've been sworn in, Mr. Arnold, I have a series of questions for you. Make sure that you understand your plea. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder your understanding today? I'm sorry?
No, ma'am.
Okay. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Okay. And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself? All right, you gotta speak loud so the court reporter can get it and we can hear the recording. I just said you have to speak a little louder for me.
Sorry. Yes, ma'am. To your question.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer.
Yes, ma'am.
And you are prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you receive a lesser sentence for pleading guilty?
No.
Has anyone told you that you, I'm sorry. Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, that probation could be affected by a guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
As to the charge of theft by shoplifting, how do you plead? Okay. All right. I will accept your guilty plea. All right. Thank you.
And Judge, you did waive 1 month of probation fees, correct?
Correct.
Going to 15, 16, Mr. Bush.
Okay. This is Brian Bush, excuse me, 23 CR 006586L. And then the FTA for position 16 ending in 1115. Is this still going to be a plea?
Yes, Judge.
All right.
Yes, Your Honor. In exchange for the plea to position 15, the state has agreed to null pros the FTA ending in 1115. For case ending 586L, state recommends 12 months probation, balance suspended, 30 days to serve, a social worker visit, and to stay away from the incident location at 756 West Peachtree, also known as the CODA building. We do ask that defense stipulate for purposes of the plea.
Defense stipulates.
Right. Mr. Bush, I understand that you wish to plead guilty. Is that correct?
Yes, ma'am. Yes, Your Honor.
Okay. And I am going to ask you a series of questions after I swear you in. Raise your right hand for me.
Right
Do you
here.
affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right. You can put your hand down. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol at this time that would hinder your understanding?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, I am, Your Honor.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am, Your Honor.
And that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
And are you prepared and agree to waive these rights today?
Yes, Your Honor.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
And do you understand that if you're currently on probation, it could be affected by a guilty plea today?
Huh?
Do you understand that if you're currently on probation, it could be affected by your plea today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, Your Honor.
As to the charge of criminal trespass and damage to property, how do you plead?
Guilty, Your Honor.
All right, I accept your guilty plea. Thank you.
I'm sorry. This was a balance suspended.
Yes.
Thank you.
Come on, roll, Bush.
Oh, no, no.
19, Mr. Davis.
Probation or just guilty?
Roll, Bush.
Who do we have?
19, Mr. Davis.
This is Dexter Davis. Is this going to be a plea
Yes, Judge.
or not? Okay. This is 26 CR 003280B. Dexter Davis is charged with 1 count of criminal trespass. Date?
Yes, Your Honor. State is recommending 12 months probation, 180 days to serve. No further contact with the victim, Jordan Knight, KNIGHT. Stay away from the incident location at 216 Delavan Street and a social worker visit. This is balance suspended. We do ask defense stipulate for purposes of the plea.
Defense stipulates.
All right. And Mr. Davis, I understand that you wish to plead guilty. Is that correct?
Right.
All right. Raise your right hand so I can swear you in. Do you affirm that the testimony you're about to receive is the truth and nothing but the truth under the penalty of perjury?
True.
All right, put your hand down for me. I'm going to ask you a series of questions to make sure you understand your plea. So answer loud and clear for me, okay? First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding today?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes.
And has anyone told you that you will receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're on probation, it could be affected by a guilty plea today?
All right.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
Goes to the charge of criminal trespass. How do you plead?
Guilty.
All right, I will accept your guilty plea and you understand your conditions, correct?
Yeah.
All right, thank you.
Problem. I'm gonna put add on 7 and 8, Mr. Jones.
Which case?
Add on 7 and 8.
Oh, 7.
How many voting days?
It's gonna be a plea.
One misdemeanor or just one time?
All right, Mr. Atai, is this gonna be a plea?
I'm gonna approve him. Yes.
Okay.
Real quick, can we verify if the charge has already been amended or not?
Well, we could write it on the plea form,
Okay.
the amended charge.
Just wasn't sure if I needed to file some paperwork or not.
I'm not sure here what this is. Yeah, Ms. Strong, does Ms. Spear need to file any paperwork to amend the charge?
Have you already filed the amended accusations?
That's what I'm trying to find out. I just tried to pull it up in Odyssey.
And so it's supposed to be failure to maintain lane and driving with license suspended, amended to no license. Oh yeah, you have to amend it. It's not amended in here.
Okay. Thank you.
You're welcome.
So I guess we can come back to that one after I amend it.
We could go ahead and take the plea. You just have to amend it,
Okay.
because I have to have it. But we can take the plea and I'll just correct it on the Senate sheet.
Okay.
All right, so what are the charges?
Failure to maintain lane, basic rules, aka too fast for conditions, and no license on person.
Okay. All right, Antonio Jones, 26 CR 00601-8Y. Understand you wish to plead guilty, is that correct?
Yes, ma'am. Correct.
All right, raise your right hand so I can swear you in. You affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Gonna ask you a series of questions. Make sure you understand your plea, all right?
Yes, ma'am.
All right. Are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
You're giving up and waiving the right to remain silent and not testify against yourself?
Yes, correct, Your Honor.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Correct, Your Honor.
And you are prepared and agree to waive these rights today, is that correct?
It is correct, Your Honor.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty? And do you understand that if you're currently on probation, that probation could be affected by a guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am. Correct, Your Honor.
As to the charge of failure to maintain lane, how do you plead?
Yes.
As to the charge of basic rules too fast for conditions, how do you plead?
Yes.
And as to the charge of driving without, I'm sorry, no license on person, how do you plead?
Yes, Your Honor. I was 16 at the time.
Okay, gotcha. So I will accept your guilty plea. And I think you just have your fines, is that correct? Oh, 20 hours of community service in a class. So you understand your conditions, correct?
20 hours of community service in a DUI class, that's correct.
Yeah, live at 25, and then you've got your fines.
I mean, I'm not unable to pay the fine, but I can do the community service. That's okay with you.
Let's see, you already have 20 hours of community service, but you have the additional fines and state, what is that?
Failure to maintain lane fine is $265. Basic rules, too fast for conditions is $250. No license on person is $10 by statute.
I was 16. It was my
So that's what, $525?
It's gonna be over 600 with his fees that go along with each charge, with each fine.
Right, so it's over $600 in fines, you understand that?
Yes, man, I understand.
Okay, all right. Good luck to you, thank you.
Man, take me back to my room, man. Let us see. I'm trying to write my room, bro. If you got add on 1, add on 2, Mr. Allen.
Okay.
And that's a plea, Judge.
Okay. Is it Quadrivius Allen?
Yes, ma'am.
All right, this is 26 CR 007611E. And then the FTA with that ending in 1042. Jake?
Yes, Your Honor. In exchange for the plea to 7611E, we are null processing the FTA ending in 1042 for position 1. State recommends on count 1 theft by shoplifting, 12 months. Balance probated 60 days to serve with credit for any time already served. The law and decision-making course, 40 hours of community service, and to stay away from the Family Dollar 100 West Broad Street in Fairburn. On count 2, state recommends 12 months probation concurrent and the statutory $300 fine. We do ask that defense stipulate for purposes of the plea.
Defense stipulates, Judge, we request a waiver of probation fees, or as many waiver of probation fees as possible, and we ask that he go non-reporting once he fulfills the requirements.
Did you ask to go non-reporting? I'm sorry.
Yes, he is.
Yeah, based on the FTA, the state would object.
I can waive 2 months of probation fees.
Did this have the custody on the probation violation for these two misdemeanor cases?
Okay, and that,
Yes,
you know, when the court date is,
I don't.
you think it's in the next week or two?
I don't. But when I get back to y'all.
Oh, yeah. Yeah.
All right, you ready?
Yes, Judge.
Okay. All right, and Mr. Allen, correct?
Yes, ma'am.
All right, understand that you wish to plead guilty, is that correct?
Yes, ma'am.
All right, I'm going to swear you in first. Raise your right hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. I'm going to ask you a series of questions to make sure you understand your plea, okay? All right, first question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol at this time that would hinder your understanding?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And excuse me, do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, it could be affected by a guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
So it's the charge of theft by shoplifting. How do you plead?
Guilty.
And as to the charge of willful obstruction of a law enforcement officer, how do you plead?
Guilty.
All right, I will accept your guilty plea and you understand your conditions, correct?
Yes, ma'am.
All right, good luck to you.
Thank you.
Mm-hmm.
All right, then we got 25, 26, Mr. Bryson.
Okay.
And this is, well, due request, Your Honor. First, I'd like to move for a bond modification. I request signature bond because Mr. Bryson was he's currently in custody only on a failure to appear. At the time that he was alleged to have failed to appear here in Fulton County State Court, he was in the custody of the Georgia Department of Corrections. So he cannot appear in court. That's the basis for my motion. And second, Your Honor, Mr. Bryson wanted to know if it's possible for the defense to make a substantive legal argument to dismiss some charges at this hearing, such as a general,
Such as the what?
such as a general demurrer. If this is the appropriate forum to make that kind of argument.
Probably not. State, do you have the demurrer? Think it would be set for motions calendar.
I do not have the demurrer.
Okay, well, I was just asking if this would be the appropriate form to do that, Judge, if it'd be possible to argue in the mirror at this SAP calendar. I wouldn't be doing it now. I don't have a legal basis, but I wanted to ask if that'd be a possibility.
Usually we don't, do we? ASG Spear, we send them up to the division, or what do we do?
Yeah, normally that's handled in division on trial line.
So we cannot move to dismiss it.
Am I right about that, Ms. Strong, generally?
I'm sorry, I was multitasking. What was the question?
That we usually don't handle the demur motions on the SAP. They usually go to the division judge for a motions calendar.
Correct.
Okay.
Right, if you get a signature bond out, the case will be transferred to a trial division, so you'd still be not guilty. Okay. All right, so, but I'd still like to be heard on a motion for bond modification, Judge.
All right.
And and that was my argument earlier, that he was in the custody of Georgia DOC. He was scheduled to appear in court.
All right, let me call this one 23 CR 006604A. The Lawrence, is it Freeson?
Bryson.
Freison, charged with DUI, let's say, DUI per se, and possession of open alcohol container. And so what is the bond presently?
It's $3,000 for the failure to appear, Judge.
All right. What is your argument? Or do you want the state to go first? I don't know. I guess it's yours since it's modification. So you
Yeah.
would be going first.
Yes, Judge, and the argument is that, he's only in custody on a failure to appear. I just checked the Georgia Department of Corrections website, and at the time that he was scheduled to appear in court on July 2nd, 2024, which is the date of the offense for the FTA, he was in Georgia DOC's custody that day.
Okay. Do you have the documentation on that?
I checked Georgia DOC's website. I looked him up by his name. I can let you know what the beginning and end dates of his incarceration for that time period. Give me just a moment.
Okay.
Right, because I show that he was picked up and released in 2024 before
Hold
that.
on a second when PD
Okay.
Atai gets back.
Okay.
All right, so according to the DOC website, his second period of incarceration began on February 8th, 2024, and his incarceration ended on June 10th, 2026. The FTA is from July 2nd, 2024, so he was about 5 months into his sentence at DOC when he picked up this FTA.
Okay. And what were you going to say, ASG Spear?
He had a booking prior to that. I do show the FTA was issued on July 2nd. But I'm just looking at some other things here. Where, Mr. Chitai, does it say where he was? I'm guessing not Fulton County based on what I'm looking at.
I don't know, but the DOC, Washington State Prison, like the state.
Okay. That's why I can't see it. Okay.
My
I do
client's
show.
interview was at Washington State Prison. I don't know where that is, but it's the DOC facility.
Okay. Based on that information, we would dismiss the FTA.
All right. Get an order to Ms. Strong on that.
Yes.
So the FTA is being dismissed out of custody on the case itself. check with Fulton County State Court. Next court, they're still in custody.
Anything else?
How are we handling his case in position 25?
And for that judge, he's not in custody on the case itself, so I guess they'll be released from Fulton County Jail if the FTA is being dismissed, and this case will be reset. He'll keep his information up to date with Fulton County State Court.
All right, so then, position 25, he's not pleading guilty to that one?
No, Judge.
Okay, so that'll be a waiver
Yes.
and further notice, okay? All right.
And 26 is being non-pros?
Yes.
Yes.
Let's go number 3, Mr. Crawford.
You're good. They should be released.
And after courtroom 2 is position 51, Ms. Williams, Your Honor.
Okay.
Ready.
All right, this is 26 CR 0034443G, Horace Crawford, 1 count of battery family violence. Is this a plea? 3 on the add-on?
And Judge.
All right. Dave?
So
Huh?
we're doing non-negotiated?
My client. Right. Judge, so I'd like to move for a bond modification on this case. He has a $5,000 bond. He's been in custody since May 9th. So he's been in custody for 47 days now, and we still don't have an offer from the state. I'm prepared to make a bond argument.
All right, state. What do you
Bond it
have?
is. Let me pull it up.
Okay.
Because it is a battery family violence, and since there is no offer, that leads me to believe that we have not made contact with the victim. So I'd like to be able to see what the injuries are. 5,000 for family violence is not unheard of. Give me just a second.
Okay.
This was reviewed for felony indictment, so let me look at one more thing. Yeah, it was an ag assault that was reduced. So based on the seriousness of the charge, although reduced, the state believes that $5,000 is more than reasonable. It resulted in serious bodily injury. He grabbed her by the neck, pushed her up the wall, and caused her to hit her head. EMTs did respond. So we believe that 5,000 based on the totality of the circumstances is more than generous.
Judge, I'm checking Odyssey now. We don't even have the affidavits for arrest. Ms. Spear read the accusation itself, And again, I'll just reiterate to this court that he's been in custody for 47 days now. And we still don't have enough, or they haven't even had victim contact the team.
I didn't read from, just to clarify, I read from the arrest warrant. I did not read from our accusation.
Oh, okay, I haven't received the arrest warrant.
And what is pretrial? What is Mr. Crawford's history?
One moment, Your Honor, I didn't get the position, so I was waiting for you to say his name.
Oh, I'm so sorry. That's 3 on the add-on.
I have a note that while the DA kicked it down, this has been an escalation of violence against the victim. There is a lapse since the last time he was arrested. There is a battery of family violence guilty on that history. So while technically this should be a felony, which I guess is why we've been in contact with the DA and opted not to go forward with that, even though statutorily it is. Again, 5,000 seems more than generous.
Okay, Your Honor, I have it pulled up now.
Okay.
He has 2 cycles from the state of New York, a 1994 conviction for driving while ability impaired by the consumption of alcohol, and then one moment, a 91 conviction for possession of controlled substance, 3rd degree, also out of New York. And then let me get into the Georgia. There are 7 cycles out of Georgia. An open case out of Cobb County for simple battery and willful obstruction.
Say that again.
There's an open case currently out of Cobb County for simple battery and willful obstruction. There is an 09 conviction. Oh, wait, I'm sorry, hold on. An 08 conviction out of Cobb County for DUI. And then a 07 conviction out of Cobb County for battery, family violence, first offense. As well as an 06 NOLO out of Marietta Municipal for driving while license suspended or revoked. Nothing further.
Okay. All right. And given his history, I'm inclined to agree with the state. I think that 5,000 surety bond seems fair and reasonable. I will deny the modification at this time and leave it at the 5,000 surety.
Thank you, Your Honor.
Mm-hmm.
All right, then in that case, Judge, this case will be reset to the next SAP calendar, and you would like an offer from the state.
If you don't mind, he's already reset for a jail bench on the 30th.
And since I haven't had contact with the victim, I can't make you a formal offer. I can tell you that in a non-negotiated plea, we would be asking for the maximum penalty on each charge.
So you're going to probably 30th. So you'll be in court there. You can okay. All right, I suppose this will be reset till further notice, and I do see an honesty that we scheduled for a jury trial calendar and Judge Maynard's courtroom. Okay. So just hang tight 5 more days. We'll have to count.
All right, who do we have next? You said 51?
Your Honor, ACDC is
Yeah.
ready, Judge.
All
Position
right.
sub.
This is 51. We're back, okay, with Venable.
Your Honor, I think it's 56, Judge.
Oh, 56 would be Alicia Williams
Yes, Judge.
that we had a waiver on earlier.
Yes, Judge. I've been in communication with Ms. Evans Battle, Judge, and I think she's on Zoom. The state
Oh,
is changing the recommendation. I'll let the state.
Okay, go ahead,
announce it.
ASG Evans Battle.
Yes, Your Honor. The state has agreed to amend the accusation to reckless driving. The offer is for the time she's already served to be commuted to time served, and there are no other conditions.
Okay,
And we stipulate for purposes of the plea, Judge, and my client is ready to enter a guilty plea on this charge.
okay. And so the only charge will be reckless driving, correct?
Yes, Your Honor. I've amended it and I filed it down just a few moments ago, so I'm not sure if the clerk's office has received it yet. If
Okay.
there's a need for clarification on it, it would be counts 1 and 2 would merge into the reckless driving, which I amended count 3, which is based on my looking at Odyssey is the only case that is actually should be on the calendar anyway, so.
All right, you see that, Ms. Strong, yet?
No, ma'am, but I'm just,
Writing it down.
taking off what I already had, so you're just giving me a moment, please.
Okay, okay.
Okay. So 1 and 2 are merging with count 3, which is the reckless driving.
Yes.
Mm-hmm.
And what, oh, I guess you're about to go through the plea again? I'm sorry, because I missed it, trying to catch up.
That's fine. As to count 1 and 2, they will merge into count 3, which is amended as reckless driving. The state's recommendation is for time served. That would be credit for time in which she's already served, that be commuted to that sentence, that she stipulate to identity, venue, and a factual basis for the plea. Thank you.
All right. And I understand, Ms. Williams, you wish to plead guilty to 1 count of reckless driving. Is that correct?
Yes, ma'am.
All right.
Thank you.
And raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Do.
Okay, put your hand down for me. I'm going to ask you a series of questions. Make sure you understand the plea, okay?
Yes, ma'am.
First question, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would render you unable to understand at this point?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, Your Honor.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
And you are prepared and agree to waive these rights today, correct?
Correct.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, Your Honor.
And has anyone promised you anything to plead guilty?
No, Your Honor.
And do you understand that if you're currently on probation, it could be affected by your guilty plea today?
I do.
And
Yes.
do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, I do.
And as to the charge of reckless driving, how do you plead?
I plead guilty.
All right, I will accept your guilty plea.
Thank you, Your Honor.
Judge.
All right, you're welcome. Thank you.
Thank you, Ms. Battle.
All right, position 9 through 12, Mr. Bennett.
Okay.
All right, let's go.
9 through 12, Mr. Bennett.
All right. This is 26 CR 001374A, David Bennett, charge of 1 count of simple battery and theft by taking. Position 10, 26 CR 001383A, charge of 1 count of battery family violence. And position 11 is the FTA 26 ending in 412. And then position 12, 24 CR 004151A. And that's a different, is that the same person? Yes.
Honor.
And discharge of a firearm at or near public highway or street. I just saw a different middle name. All right, state.
Yes, Your Honor, we'll just go down the calendar.
Okay.
Case ending 1374A, state recommends on count 1, simple battery, family violence, 12 months probation, balance probated, credit for time served. We are asking 30 days for restitution to be factored. The Family Violence Intervention Program, 40 hours of community service, no further contact with the victim, Gail Williams. There's no stay away necessary. The victim is moved. On count 2, theft by taking, we are recommending credit for time served. Do you want me to go on to the next one, or do you want to address these individually?
No, go on to the next.
Okay.
And we'll do them all together.
Position 10, case ending 1383A, battery family violence. State recommends 12 months probation to run consecutive. Credit for time served. Still enforcing the FVIP, an additional 40 hours of community service. Same, no violent contact with the victim, Gail Williams, no stay away. FTA 412, we are null processing in exchange for the pleas. Position 12, case ending 4151A, discharge of a firearm. We are additionally asking another 12 months of probation, 365 days to serve, forfeit all firearms, and to stay away from the incident location at 4100 Wendell Drive. We do ask that defense stipulate for purposes of the plea.
Your Honor, we do so stipulate for the purposes of the plea. We do ask that Mr. Bennett be allowed to have his probation be phone-in report. He will be going to a VA clinic. It's in hospital, not in hospital, inpatient therapy. And it's approximately 6 months. They're going to provide him with housing, with food, with training, with therapy. He does want me to note that the reason for the discharge was he had recently lost his wife and he was not in his right state of mind on substances, which is part of why he's going to this VA treatment therapy. I do believe that he is doing what's best for his life moving forward with this VA treatment. But since that is down in Savannah, it will be hard for him to come up to Fulton. So we're asking that his probation be phone-in report, and that we are also asking for the first couple months to be waived, since he will not be working during this first couple months in the treatment program.
And you said it's in Savannah?
Yes, Your Honor.
Okay. And how old is Mr. Bennett?
66.
How old is Mr. Bennett?
66, Your Honor.
66. Okay. All right. State, I guess you probably don't have any objection to phone in. It's about the only way he'll be able to do it.
Yeah, that's fine. I mean, we're asking for a total of 3 years. So while he's at the facility, we have no problem with phone and report. However, of course, once he leaves the facility, we would ask that it go back to in person.
Okay.
And we would merely ask that if he were to find housing, say down in Savannah through the program, that he be allowed to stay on phone and report, just depending on where he moves back to after the program.
Right. If if he stays in Savannah after the program, he would continue phone in, but he's got to keep his address updated
Yes.
and let probation know,
And the
obviously.
phone will be updated with not just USPS.
All right. There's nothing else. We're ready to take the plea.
And I think I misspoke. I said Savannah, it was Augusta.
Oh, Augusta. Okay.
So my apologies, Your Honor.
No worries. All right, Mr. Bennett, I understand that you wish to plead guilty and you still need to, or did you do all, you did all of them, correct?
Yes, Your Honor.
Yes, we went through all of
ASG
them.
Spear,
Yes.
because I heard about the weapon. Okay, weapons as well. And so if you have any firearms, Mr. Bennett, you need to turn them into the sheriff's department, I guess, before you go. Or if you, I don't know if you will have them with you, but you're forfeiting to have any firearms while you're on probation, okay? All right. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Right, put your hand down for me. I'm going to ask you a series of questions to make sure you understand your plea to all of these charges in the three cases, okay? All right. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder your understanding at this time? Can't hear you.
No, ma'am.
Okay. All right. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, it could be affected by your guilty plea?
Yes, ma'am.
And do you offer these guilty pleas freely and voluntarily with the full understanding of the charges against you?
Yes, I do.
All right. So as to the charge of battery family violence, how do you plead?
Guilty.
All right. And then the next case, as to the charge of simple battery family violence, how do you plead?
Guilty.
To the charge of theft by taking, how do you plead?
Guilty.
And as to the charge of discharge of a firearm on or near public highway or street, how do you plead to that?
Guilty.
All right. I will accept your global guilty plea to the 4 cases, or 3 cases, and then the FTA will be no pros. All right. So you have a lot of conditions, but the first one being hopefully you successfully complete the inpatient clinic. Okay.
Yes, ma'am.
All right. Thank you.
I'm sorry, and just to confirm, just the telephone recording, no waivers or anything, correct?
No.
Okay.
Okay. This got 2930, Mr. Herb.
You said 29?
Yes, ma'am.
Okay.
Before we start with that, I have brief announcements to make for 3 cases.
Okay.
Positions 17 and 35, those are being reset to the next available SAP.
Okay. 17 is a reset and 35.
Yes, both Mr.
Okay.
Copeland. And position number 18, Robert Davidson, he needs to be reset to competency calendar.
And what number was that again?
Mr. Davidson is position 18.
Oh, 18. And that needs to be reset to the competency of which I believe was July 9th, was it,
9th.
Mr.? Okay. All right. Thank you, PD Chitaya. All right, and this is Johnny Hurd, 24 CR 003906H.
Yes, Your Honor.
This a plea?
It is, Your Honor.
Okay.
I'm sorry, I thought Mr. Herb was not, his cases were not crossed.
Oh,
There-
that's what I saw on the calendar.
There was the possibility of a null pros, and I fully take the blame for this. I should have put on my announcement that it was simply a possibility and we still need him to brought down. So my apologies. But we were not able to get the null pros, but we do nonetheless still have a very, very reasonable deal.
Okay.
Your Honor, that mistake was on my part. Mr. Judd did communicate that to me and I just put it in an email wrongly, so I apologize, Judge.
All right, we'll blame you, but we'll forgive you. All right, thank you, PD Haddad. All right. And Mr. Hurd, also, I read the first one. He has in the FTA 1063.
Correct, Your Honor. In exchange for the plea to position 29, we are going to null pros the FTA ending in 1063. On case number, position 29, case ending 3906H, we are amending the DUI to a reckless driving. I need to do that still, and it will be credit for time served, no further terms and conditions. I don't know. I don't have how long he's been in there, but it will be whatever time he's already served. The rest we can null pros. We do ask defense to stipulate for purposes of the plea.
Well, we're just
So we're no prosing 1, 2, 3, 4, 5 other charges.
Oops, correct.
Parked along the roadway, possession of open container, failure to have license on person, littering in public, drunk. All of those will be null pros.
Yes.
Okay. When was he arrested, PD Judd? Do you have that?
So, Your Honor, he's been in for 16 days as of the recent arrest, and according to my math, he has 182 days from the underlying charge.
Okay.
But
All right,
if someone
thank
wants to
you.
double check me, please always double check my math.
That's okay. All right. And so, Mr. Hurd. Oh,
Well, you're getting credit for that, sir.
Yeah, but I've been down the road for 5 years. That's why I wasn't able to appear in court.
Yeah, Your Honor, Mr. Hurd just does want me to mention that he has been locked up down the road for about 5 years. And that is actually the reason for the FTA, that he was in custody at the time.
thank you. Okay. Thank you for that clarification, Mr. Hurd.
Yes, ma'am.
All right. And you wish to plead guilty today, is that correct?
Well, not to the FTA, right?
Well,
That's
you-
up and down the road.
The FTA is being null prost if you take the plea to the one charge of reckless, it's a reckless driving. That's what you're pleading guilty to today. You clear about that?
Yes, ma'am. I guess, yes, ma'am.
Okay, raise your right hand for me and I'm gonna swear you in first. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. I'm gonna ask you a series of questions to make sure you understand your plea, okay?
Yes, ma'am.
All right, first question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder you from understanding right now?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
All right, and do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to the trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
And has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And you understand that if you're currently on probation, it could be affected by your guilty plea today? Okay. And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And as to the charge of reckless driving, how do you plead?
So the DUI is being reduced down to reckless. So
It's just one charge of reckless driving.
And that's it.
Yes, sir.
Yes, ma'am.
Are you pleading
And how do
guilty?
you plead to that charge of reckless driving?
Not guilty. I mean, guilty.
Guilty, okay. All right. I will accept your guilty plea. There are no conditions. And credit for time served, okay?
Yes, ma'am.
Thank you, Your Honor.
All right, thank you.
And thank you, ASG Spears.
Okay. All right, next we got, number 53, Mr. Warner.
Okay.
Yeah.
This is 26 CR 003847D, Orrin Warner. Charged with one count of criminal trespass. And this is going to be a plea.
Yes, Your Honor.
State?
Yes, state recommends 12 months probation, 30 days to serve with credit for any time that he's already served. It's going to be balance suspended, no further contact with the victim, Rosalind Montgomery, and to stay away from 2810 Church Street. We do ask that defense stipulate for purposes of the plea.
We do so stipulate for the purposes of the plea, Your Honor.
Okay. All right, and Mr. Warner, I understand that you wish to plead guilty. Is that correct?
Yeah.
Okay, speak a little louder so we can hear you, okay?
Yes, can I ask you to do still the same from yesterday being 12 months of probation with time served today?
So the probation is actually being suspended. So as long as you don't get in trouble during those 12 months.
Okay. All right, raise your right hand for me a little bit. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, yes.
Yes, okay, put your hand down for me. I'm gonna ask you a few questions to make sure that this plea is free and voluntary, okay?
Thank you.
All right, first question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder you from understanding right now?
No, ma'am.
Okay, and are you satisfied with the services and representation of your attorney?
Yes.
All right, and do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
You're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
You won't be having a trial because you're pleading guilty.
Okay, you have to say yes.
Yes.
All right, and you are prepared and agree to waive these rights today to plead guilty, correct?
Correct.
And has anyone promised you anything to plead guilty?
No, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Okay. And do you understand that if you're currently on probation, it could be affected by the guilty plea today?
Can you say that one again, please?
If you're currently on probation, it could be affected by the guilty plea today?
Oh, yes. Yes, ma'am.
Okay. And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, definitely. Yes, ma'am.
Okay. So as to the charge of criminal trespass, how do you plead?
Guilty.
All right. I will accept your guilty plea and you understand your conditions, correct?
Yes, ma'am.
Okay. All right, good luck to you.
Thank you, Your Honor.
All right, you're welcome.
3738, Mr. Mott.
Okay. All right. And is this going to be a plea?
It is, Your Honor.
Okay. All right, this is 24 CR 000-559C, Matthew Mott. And then the FTA is 26 ending in 1066. State?
Yes, Your Honor. In exchange for the plea to case ending 559C, we are agreeing to null pros the FTA ending in 1066. For position 37, criminal trespass damage to property. We are asking for 12 months probation, credit for time served. We are asking for a restitution in the amount of $500, but we are asking that it remain open for 30 days. No further contact with the victim, Stacy Gosnell, an ADET and 12 anger management courses. While we do have an amount, we are still asking for it to be open so that the restitution can be accurate. She provided us a rough estimate, but no receipts at this time. So before we have the defendant sign off on a definitive amount, we do ask that it just stay open for 30 days for her to provide the receipts. We do ask that defense stipulate for purposes of the plea. Thank you.
We do so stipulate for the purposes of the plea, Your Honor.
All right. And so, Mr. Mott, I understand that you wish to plead guilty. Is that correct?
Yes, Your Honor.
All right. Raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right. Put your hand down for me. I'm going to ask you a series of questions so that you understand your plea. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder your understanding at this time?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Very much so.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
I do.
And do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
And you are prepared and agree to waive these rights today, is that correct?
Yes, Your Honor.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, I have not.
And has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, it could be affected by your guilty plea today?
Yes, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
I do, Your Honor.
And as to the charge of criminal trespass and damage to property, how do you plead?
Guilty.
All right, and you understand your conditions, correct?
I do, Your Honor.
Okay. All right. So that will conclude that, and I'll accept your plea.
Thank you. Thank you, Your Honor.
You're welcome.
And this guy 42, 43, Mr. Sharp.
Okay. This is 24 CR 003362D, Larry Sharp, charged with 1 count of battery. And the position 43 is a 26 FTA ending in 1117. Is this going to be a plea?
It is, Your Honor.
Yeah.
All right, state.
Yes, Your Honor. In exchange for the plea, we are agreeing to null pros the FTA ending in 1117. Position 42, we are asking 12 months probation, 30 days to serve, balance probated, no further contact with the victim, Darian Jackson. Stay away from the incident location, 4055 Rickenbacker Drive, and 12 anger management courses. We do ask that defense stipulate for purposes of the plea. Thank you.
We do so stipulate for the purposes of the plea, Your Honor. Mr. Sharp would like me to let the court know that the reason for the FTA was he was incarcerated in Gwinnett at the time. So he does appreciate the dismissal. And after this, he will be going to Gwinnett, and he does not currently have a mode of transportation or active employment. So we're asking that he be allowed to do non-report, and if the court is not willing to do non-report, then phone report.
Based on the FTA, the state would object to non-reporting.
All right. All right. We'll just go forward and he'll have to report the whole time. Is that okay with you all, PD Jet?
I'm sorry, Your Honor.
He would have to go reporting the whole time. Is that okay with you all? State objects.
He would not be able to do phone report.
Well, he can do phone report, but he will have to report the whole time.
Understood.
They object to him going non-reporting.
Understood.
Okay. All right. Mr. Sharp, I understand that you wish to plead guilty. Is that correct?
Yes, Your Honor.
All right. Raise your right hand for me so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right. Put your hand down. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder your understanding at this time?
No, Your Honor.
And are you satisfied with the services and representation of your attorney?
Exceedingly.
Okay. And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am. Thank you.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, Your Honor.
And has anyone promised you anything to plead guilty?
No, Your Honor.
And you do understand that if you're on probation, it could be affected by a guilty plea today?
Yes, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, Your Honor.
To the charge of battery, how do you plead?
Guilty.
All right. And I will accept your guilty plea. Understand your conditions, correct?
Yes, ma'am.
All right. Good luck to you.
God bless you. Thank you, Your Honor.
All right, go on to number 40, Mr. Perry.
Okay.
And this is going to be a plea, Your Honor.
Okay. This is 26 CR 00385H. Bernardo Perry. Sorry if I'm mispronouncing your first name. Date?
All right, okay. After speaking with defense counsel, we have agreed to null pros count 1, giving false information to a law enforcement officer. On count 2, obstruction, we are recommending 12 months probation with the $3 standard fine statutorily provided. Count 3, we are recommending credit for time served. Count 4, we are requiring the $500 fine as required by statute. Obviously balance probated unless judge alters this in some way. We do ask that defense stipulate for purposes of the plea. Thank you.
Your Honor, we do so stipulate for the purposes of the plea. We would like to point out that Mr. Perry has a hold out of Florida, Jacksonville, Florida, and we're unsure how long he will be in there or even when they'll come to get him. So we are asking that his report be phone-in report while he needs to report. And then we are asking that once he completes the conditions of paying the $800 fine, that his probation go non-report.
Date?
Based that he has an out-of-state hold, state would object to non-reporting.
Okay. I will not let him do that. So he needs to report the whole time.
Will be allowed phone-in report, Your Honor?
We'll allow phone in.
Thank you, Your Honor. Thank you.
And so the first charge, giving false info, that will be null pros, correct? So he's only pleading to counts 2, 3, and 4?
Yes, Your Honor, that is correct. Based on my review of the case, it does appear that the false info is also the obstruction, and so we are getting rid of that. It does seem redundant.
Okay. All right. So Mr. Perry, I understand that you wish to plead guilty. Is that correct?
Yes, ma'am.
Okay, speak up a little bit for me, so that we can hear you. I'm gonna ask you a series of questions to make sure you understand your plea. All right? Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
Okay, put your hand down for me. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol at this time that would impair your understanding?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving your right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today?
Yes, ma'am.
And has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And you do understand that if you're on probation, that probation could be affected by this guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Your Honor.
All right. And so as to the charge of willful obstruction to the law enforcement officer, how do you plead?
Guilty.
Distracted driving, how do you plead?
Guilty.
And driving while license suspended or revoked, how do you plead? I didn't hear you.
Guilty.
Okay. All right. We'll accept your guilty plea.
Thank you, Your Honor.
All right. Thank you.
I'm
Thank
sorry,
you.
I missed, it was only telephone reporting, correct? No waiver of anything else?
No.
Okay.
Actually, Your Honor, since he will be in Florida for a while, could we have the first 3 months probation fees waived?
I'll waive the first 2.
Yes, Your Honor. Thank you.
Okay. You hear that, Ms. Strong?
Yes, ma'am, thank you.
Okay.
That should do it, Judge.
That's it?
I believe so.
Okay. Let's see, what else do we have that we haven't heard from? To see if we blame courtroom 2 or not.
Your Honor, this is David Schaefer representing Mr. Michael Owusu. We have a bench warrant that is outstanding.
Okay. We'll finish this in a second and then we'll come into you next.
Thank you,
Hold
Your
on
Honor.
1 second. All right. Thank you. We have everything, Casey? I'm sorry, Ms. Strong.
Okay.
I'll let you take a look.
What happened with position number 23?
Let's see.
That was, they said that was at the South Annex and they need to speak.
Oh, didn't hear back. I don't know. Foster?
We just did a bond on that one, I think.
Did
Oh,
we?
you did a consent bond? We didn't hear that at
No,
all.
not a consent, but we didn't? Okay, my mistake.
No, we haven't heard that one.
Your Honor,
Mr.
that's, well, I'll just ask to have it reset, to next week. He's got much bigger fish to fry, but I can't waive his arraignment without, confirming that's what he wants, or obviously if he wants to take a plea as well, so.
Okay, so that'll be a reset.
Thank you, Judge.
Thank you. What else you got, Kate, Ms. Strong? I see 24 is a transfer.
And Spear, what were we doing, Mr. Spear? I know I remember hearing it, but I don't think I notated it on my calendar. Was that the ones that Ms. McLeod was supposed to speak to, or was she resetting these? Waiving these?
I have it marked as a reset.
For which one?
For positions 47 through 50.
50.
It's supposed to be a reset.
For regular or comp?
Just regular,
Regular.
so Ms. McLeod can speak to him and
Okay,
that good stuff.
thank you. And I'll go through the calendar in a moment, but position number 52 was null clause based on the amended bond for 51, correct? Or was the amended bond for
Ms. Venable?
correct?
Ms. Venable was waived.
Huh?
Y'all finished?
I have Ms. Venable waived.
Oh, I do.
Oh, and it was an amended bond, okay. But it was an amended bond on Ms. Venable as well, correct?
That is correct.
Yes.
Okay, thank you.
Yes.
All right, Judge, did you want to go through the calendar now, or did you want to wait?
No, we can go. We can do it.
Okay, position number 1 was a plea. Position number 2 was null pros. Positions 3, 4, 5, 6, 7, and 8 are being reset for July the 9th, excuse me, SAP
Excuse me,
calendar.
Miss. It's comp, but
I was getting it at 11
Oh.
a.m.
yes. You said SAP, that's why I came in.
No, I meant SAP comp. 9 and 10 were plea. 11 was non-pros. 12 was a plea. 13 was a plea. 14 was non-pros. 15 was a plea. 16 was non-pros. 17 was reset for next Thursday's SAP calendar. 18 is reset for the comp calendar on July the 9th. 19 was a plea. 20 was released. 21 and 22 are being reset for next Thursday due to medical, as well as position number 23 is being reset for next Thursday. 24 was transferred to Superior Court. 25 was waived arraignment. 26 non-pros. 7 was a plea. 28 was non-pros. 29 was a plea with 1 charge taking the plea. The remainder of them were non-pros. 30 was non-pros. 31 and 32 waived arraignment. 33 and 34 waived arraignment. 35 is being reset for next Thursday's SAP calendar. 36 was a plea. 37 was a plea. 38 was non-pros. 39 was a plea. 40 was a plea with the first position non-pros. 41 is being reset for the comp calendar on July the 9th. 42 was a plea. 43 was non-pros. 44 was a plea. 45 was non-pros. 46 was a plea. 47, 48, 49, and 50 are being reset for July the 2nd. 51 was an amended bond with a $5,500 surety bond. 52, but their 51 and 52 were waived arraignment. 53 was a plea. 54 and 55 were a plea. 56 was a plea. Oh, and Mr. Wilson's case is 57 through 64 are waived arraignment. And then on the add-on calendar, position number 1 was a plea. Position number 2 was non-pros. Position number 3 is being returned to the division for his court date on June the 30th. Position number 4 was a plea. 5 and 6 waived arraignment. 7 was a plea. 8 was non-pros, and 9 was an amended bond of a $4,000 signature bond through pretrial level 1.
What was, make sure I had 35?
You said 35 was reset for July the 2nd. He was also position number 17, I believe it was.
Okay, that's right. Okay, gotcha. I don't have anything else. All right, everyone. See you next time.
Thank you, Your Honor.
All right, thank
All right,
you.
thank you.
Have a good weekend.
Judge, are you doing, I apologize, are you doing your bench warrants now before you do the comp?
Yes. And let me see, Ms. Strong, I did not get to print, my printer is jammed.
Which calendar are you looking for, Judge?
The both of them. I couldn't print the competency or the probation.
No, it's a bench.
I
DB
mean bench. It's only
Okay.
one.
It's two people on the DB bench.
Okay, hold on. Let me at least pull it up. I got it here, but not able to.
I missed the attorney's name. It's here on the first position for Mr. Aus. I don't want to mispronounce his name.
David Schaefer for Mr. Owusu.
Thank you, Mr.
You're
Sherman.
welcome. Thank you.
And Ms. Yearns is on too. She's the second position judge. I'll send it to you in a moment, though.
Okay.
So am I correct in assuming that the only ones on the bench warrant calendar are handled by private attorneys?
Correct.
It looks like,
Okay.
yeah.
So
Thank
did you want Ms. Yearns to contact you, Mr. Judd? Did you want me to put the number in the chat for her to contact you?
So is she not being handled by a private attorney?
No, that's the other position number one that's being represented by the private attorney.
Understood. I actually did not get the bench warrant calendar. If you wouldn't mind emailing that to me.
Okay, I'll send it to you over in just a moment.
Thank you so much. I just assumed that there wasn't.
Ms. Young, I see Miss Spear, it looks like is gone. If you will, just go ahead and send that to me as well. I'll look at it.
Sure.
Thank you.
Okay, so I don't see where it was sent out at all. So just give me a moment.
I know, maybe, yeah.
Yeah, I don't see it. I only see the comp calendar, but yeah, can I put the case numbers in there? It'll be quicker than trying to generate a calendar. Or would you like me to send them in an email in with the charge and the case numbers? Because there is no calendar.
Whatever's easiest for you.
Okay, I'll send it over. Just give me a minute.
Would it be helpful if I sent her mine?
Oh.
Mine has notes on it, but.
You have the DB benchmark calendar?
Oh, no, I thought you meant the comp calendar.
Oh, no.
We have the comp. Yeah, we
Okay,
got
then,
the
yeah,
comp.
I don't have the DB calendar.
Okay, give me a moment.
Okay.
Yeah.
I sent the email, Mr. Judd.
Thank you.
You're welcome, and you, Miss, as well, Ms. Evans Battle.
Is Miss Yearns in the Zoom? Yes.
She is.
Miss Yearns, I'm gonna put into the chat, or I'm gonna do a personal chat to you, the phone number to call. So if you can just call that and we'll talk real quick.
Okay, thank you.
Thank you.
So once you send me the phone number, go ahead and give it a call and
Yes, ma'am.
leave here? Okay,
Yes, ma'am.
alrighty, thank you.
Right now, I'm currently homeless right now.
No, it was mysterious.
Yeah, it just kind of started with Jason. Huh?
And Miss Yearns, I just sent that to you.
Alrighty, I see it now. I should be calling you within the minute.
Perfect.
Okay. What are we waiting on? Ms. Strong,
Yes, ma'am.
we're waiting on everybody to sign on or what?
No, I think Ms. Evans Battle may have been looking at the information that I sent her for the DV bench. Because the first, I don't want to mispronounce his name, has a private attorney.
Okay. So we just have the one case, right?
No, it's two
You
cases.
just sent me. You just
No,
sent me
it's-
one. I don't have anything. You just
You
sent
didn't
me an email with one case.
It should have been two, Judge.
Let's see.
It should have been two defendants' name in there,
Oh, let's see.
Michael and Jillian.
Okay. Go back.
You see?
Oh, I see two. My
Okay.
bad.
No problem.
Are they ready? 12 o'clock.
Yes, Your Honor, we're ready.
Thank you.
If Miss Evans Battle is ready.
We gotta wait for the state.
Yes, because Miss Spear logged off.
Okay. There she goes. Thank you. All right, this is the first matter, which is Michael Owusu, and I apologize for mispronouncing that name. 15 CR 000188. What do we have, state?
Yes, Your Honor, it appears that Mr. Owusu had a court date on June the 11th of 2015. And he did not appear for that plea and arraignment. He had previously appeared, this case may have been going to diversion, but apparently they sent it to the division. There must not have been contact or compliance. And a warrant was issued at that time. There was a bond forfeiture hearing November the 15th of 2015. And he appears to have been picked up on this case, on maybe another case, or this warrant. I didn't get that far to see where it was. The address that was listed in the act at the time of the incident that was listed in the warrant is the address that we still have on file. So if he moved, he failed to notify the court that he had moved. And so we are here today for that failure to move or failure to provide us with a different address. And if the clerk can look, I didn't see a return of service from that location, but if you will look, are you able to look for me?
Yes, give me 1 second. Am I
Thank you.
doing something weird? Okay. Oh, you said, did I see it what time? No return notice.
Correct. So the address that we have is actually the incident location, and that is the 417th Street apartment. And we didn't have an email address or any other address in which he would have been sent notice to. And yeah, I don't see even at this point in time that the address is being changed. So the state's position, of course, would be that that the warrant not be set aside, and that that he report and would turn himself in at this particular time to be based on the outstanding warrant that is in place. Nothing further.
All right. Is it Attorney Schaefer?
Your Honor, Mr. Owusu was taken into ICE custody in 2013 and deported from the United States in 2014, returning to the United States early last year. So it appears that at the time he was required to make court appearances, he was not able to make court appearances because he was not here. And so we would like to engage the state on conversations about the underlying charge. Mr. Owusu is back in Atlanta. We're trying to work towards a resolution of this case. But the reason that he was not able to submit to the jurisdiction of the court was because he was not in the country to do so. And so based on those grounds, we would ask that the court entertain setting aside the warrant, and we can, hopefully continue towards resolution of this case from here.
All right, state, what do you say to that?
That is, if he can you provide me the if the attorney can provide the documentation that he was deported. And so, the state, for the reasons stated, he's an officer of the court. I take his word for the purpose of this hearing today, and the court can do a one-time set aside. He needs to provide the clerk in writing with his new address. And that would mean he would have to go down to the courthouse, I think is the preferred method, and submit that to the clerk's office. And if you will just email me, if you need my email with the documentation. I'm sorry, I didn't catch your name.
It's no problem.
Miss Strong said she can take it now.
Okay, then. Great.
Yes,
What is the
thank you.
new address?
Your Honor, I have it. If you can give me 1 second, I'm happy to provide it.
If you,
Okay.
Mr. Schaefer, if you could just put it in a check directly to Ms. Strong, that's okay with me.
Okay.
Thank you.
Yes, Your Honor. And Your Honor, if the court would permit, I may need a little bit of time to provide the documentation of the ICE custody and the deportation, as we were pretty recently retained on this case. But
If you can just put your email address in the email, I'll put my email address in the chat, and then you can just send it to me after court. That'll be fine.
Thank you. Thank you so much.
All right, and I will grant the order for the one-time set aside of the warrant. And your client will keep in touch with you and be able to know about any future court dates.
And he would need to prepare the order as well.
Right. You can prepare that order, Attorney Schaefer, and send it to Ms. Strong.
Yes, Your Honor.
All right, is there anything else?
From our side,
Ms.
not at
Strong?
this time.
From the state, Your Honor.
All right, this matter's concluded. We'll go on to the next one. Thank you.
Thank you, Your Honor. May we be excused?
Yes, you may. Thank you.
Right, yeah, we don't have any.
Okay.
Good morning, good afternoon, Your Honor. How are you?
Good afternoon. How are you?
Good. Just wanted to let everybody know we do not have any pleas today. So once the court reporter is done, we will need that.
Okay. Thank you.
Thank you.
And we have one more matter. What's the second matter? Jillian Yearns. Ms. Yearns?
Hi.
Hello. Do you have a hoodie on?
Yeah, sorry.
Okay, thank you.
You're welcome.
All right, this is case number 26 CR 002549C. What do we have, State?
Yes, Your Honor, it appears that that she missed a court date as well. Her court date appears to have been June the 4th of 2026. And I have to go to a different screen to find out where notice was sent.
If it makes it easier, we are stipulating that the court has the correct address.
Okay, that they have the
Okay.
correct address and it had
Mhm.
not been changed.
It has not been done.
Okay.
Okay. All right.
Well, I don't know what the basis is for her not appearing in court. So,
All right.
you know,
If it's easier, we can go.
it would probably be easier.
Okay. Your Honor, Miss Yearns simply was confused about the court date. She thought it was June 10th. She was working June 4th, and so she came into the courthouse on June 10th when she thought her court date was, found out that she had missed her court date. Immediately, same day, went to the clerk's office and got put on today's calendar. Your Honor, I have, excuse me, I have told her that what she should do is every other week, choose a day, Monday, Tuesday, Wednesday, Friday, whatever. Choose a day, and that day, every single week, check the website or call the clerk, confirm when the next court date is. Even if you think you already know when it is, call and confirm, or check on the website and confirm. We don't believe this will happen again. After she reset her court date on June 10th to today's court date, she then went in yet another time to follow up and called every single day to confirm that there was not a bench warrant out. For some reason, they told her that there was not a bench warrant, even though she is on today's calendar. So we're asking that the bench warrant be set aside. She is taking this seriously. It was a simple misstep on her calendar.
Does she have any other FTAs from the past?
Not that I'm aware of, Your Honor.
Okay. And this is battery, family violence. 2 counts, and then, well, I'm sorry, then a separate simple battery, and then a cruelty to children. Okay.
And I have this as the first arrest.
Okay, first arrest. Okay.
So state won't oppose a one-time set aside.
All right, we'll do that.
Thank you, Your Honor. Thank you, ASGM.
Thank you.
All right. All right, you're welcome. Take care.
Thank you. Do you think I can text you again and ask you a question very quickly?
That was the jailhouse, so you won't be able to text me. You can call me real quick and I'll pick up.
Okay. Should I leave here or still stay in the Zoom call?
I believe the judge has excused you.
Okay. Thank you so much, everybody.
Use. Thank you.
All right.
And Your Honor, with that, that completes my business with the court. May I be excused?
Yes, you may. Thank you. See you next time.
Yes, ma'am.
All right. Mr. Bartell's still there?
Yes, I'm here, Judge. I think we're ready to begin whenever you are.
All right, we're ready.
Okay.
Judge, you want to stay on the live stream for this, or would you like to stop it?
Huh?
Stop the live stream since we're still.
Oh, yeah. Yep, stop the live.